Our seminar for today will be conducted by our guest lecturer, Mr. Guerrero. Mr. Guerrero attended the University of Papua New Guinea School of Law from 2005 to October 2008, and he graduated with the Bachelor of Degree with second-class honors. He then attended the Papua New Guinea Legal Training Institute during 2009, graduating with a postgraduate certification of completion of legal training and an academic prize for attaining first place in the subject of PNG taxation law. Mr. Guerrero then attended the Mitchell Hamline School of Law in St. Paul City, Minnesota, United States of America, during 2016, wherein he obtained a Master's of Law degree with particular research on intellectual property law. Mr. Guerrero continues to practice law in Papua New Guinea in the main areas of commercial law, which is largely corporate regulatory and advisory in nature. I would like to invite Mr. Guerrero on stage to begin his seminar.
Good morning, everyone. Thank you for taking your time out of your busy schedules to come down. And thank you to the Master of Ceremony for that generous introduction. Today's seminar is looking at the 8 categories of intellectual property and how an indigenous SME can apply such intellectual property in the production and development of their goods and services that specifically include traditional knowledge and more importantly, this leads to the protection and the development of the cultures from which they originate from. So, So what are the 8 categories? The 8 categories are, firstly, you could use copyright to protect the traditional cultural expressions. You can use, secondly, industrial designs to protect the look and the feel of your culturally inspired products. You could use trademarks to register distinctive indigenous words, names, and symbols. You can use certification and collective marks to distinguish your goods. The next category is geographical indications as a way to link goods to a specific area. You may also use patents to protect innovations that are based on traditional knowledge, and you may use trade secrets to protect confidential traditional knowledge. And lastly, you can use unfair competition laws as a defense mechanism against intellectual property infringement. Our category of unfair competition. You may use unfair competition laws as a defense mechanism for infringement of intellectual property. In order to do this, you must have established the reputation or distinctive goodwill of your product, and that someone else was claiming that their good was in actual fact your good, and it was an imitation of your product or service. So here, acts or practices contrary to honest business practices need to be discouraged. And in PNG, the laws against unfair competition may be used to protect traditional knowledge and traditional cultural expressions. This is through the Independent Consumer and Competition Commission, and also through the case laws of passing of actions. Um, so many indigenous peoples and local communities will already have a distinctiveness about their culture and the products associated with their culture. And so it would be not that difficult to prove that you had the goodwill of the handicrafts, artworks, or traditional products. And you may then apply the thought of passing off, where someone is indicating that they have the goods that they have produced have been endorsed or established by a particular community or yes, or a cultural group. So once again, the plaintiff bringing the action must prove, particularly that they indeed had the goodwill, and that the goodwill was in danger or was actually being damaged by the misrepresentation of the imitated good. Let's close off with the final example. So here is an example from Australia. A particular business was engaging in unfair conduct in the sense that it was representing that its goods were authentic Aboriginal art and products, when in fact there were no such creators that were in connection with that business. And here the Australian Competition and Consumer Commission took up the proceeding to, under the Trade Practices Act, to seek an injunction from the federal court to stop the practice of representing to the public that the goods were Aboriginal in nature, and that and so the court agreed with the ACCC and ordered the costs and also restrained the business from such conduct for a period of 5 years. And it also asked the business to write to the consumers that had bought their products to advise them that their products were, in actual fact, not what they represented. And so that's basically the presentation. Those are the 8 ways in which a SME can use intellectual property to protect and promote their business. So I would be very happy to receive any comments, suggestions, or questions in relation to what we have discussed. What do you see? That's it? Okay. Thank you very much for taking time out from your busy schedules to attend this seminar and celebrate World Intellectual Property Day. Thank you so much.
Thank you, Mr. Guerrero, for taking time to conduct this seminar with us. I'm sure all of us here, and those watching as well online, have learned a great deal about how concepts of intellectual property law can assist indigenous SMEs. I would also like to thank Mr. Pokawin, as well as the president for UPNG Law Student Society, and her team for organizing this event. And thank you as well to everyone for attending. Have a great day.